Welcome, everyone. Thank you so much for taking time out of your day to join us. We're so glad to have you. I'm Jill Cox with Heritage Title. I wanted to mention real quickly, as we all know, we've seen some adjustments in our market. And we as sales executives at Heritage, we would love to meet with you one-on-one to help you implement some marketing, streamlined, ongoing, consistent marketing. If you haven't had that in place the last couple of years, now's the time to really get that going. We've got some great resources for you to do that. So please reach out to your sales exec. We'd love to meet with you and help as we head into these changing markets. And I would also like to mention our upcoming industry updates. So please save the date. October 6th, Mike Simonson, he's the CEO of Altos Research. They're a nationwide real estate data company. They track every single transaction that occurs throughout the United States, and they provide weekly updates on that. So really great information to keep a pulse of what's happening in the market on a national level. And then November 3rd, Damian is going to be talking about changes with the forms. So please join us for that. And with that, I'd like to introduce our speakers today. The two gentlemen who really need no introduction, Scott Peterson and Damian Cox. These are their pre-pandemic photos and then their post-pandemic photos here included.
Where did you get that?
You can find anything on the internet. A Google search yields so many fruitful things.
Those are screen grabs, I think. I think both of us look respectively insane. Great big bulging eyes.
What the last couple of years did to a lot of us. So these really are gentlemen that don't need a big introduction. Everyone knows Scott, but I just want to say a big thank you so much for your time today. And Damian, as always, for joining each month. So with that, I'm going to stop my share and turn things over. And we're going to let the gentlemen kind of go through and present on some topics that they prepared for today, but then we'll open things up to Q&A. So if you do have questions, please put that in the Q&A and we will address as many questions as we can. So thanks again for coming. And with that, Scott, we'll let you take it away.
Awesome. Well, I also need to say about the actual headshots or the profile photos. I think Damian and I both might need to update our photos there. Those are... We're starting to do the realtor thing where it's like, I don't know if you really look like your business card anymore in that picture.
I like pulling the one from my high school, of course. Yeah, just pull it from high school. That's what most of them do, isn't it?
Yeah, well, maybe, but I got the gray in the beard that wasn't present in that old headshot. So. Thanks, Jill, for having me. You do a great job with these things, and it's always a pleasure to get together and collaborate publicly a little bit with my friend and your hubby here, because we always have some fun stuff to talk about. And we've got a list of some things. I think one of the things when Damian and I were talking about and kind of prepping for this yesterday, I'd start talking a little bit about some of the shift that, well, I don't need to tell anybody that's on this call that, we've seen a pretty dramatic shift in the market over the last 5 or 6 months.
We're not doing appraisal gap guarantees and escalation clauses and multiple offers today. That's what I prepared for.
Different topics. I think that's probably, I think I did this last year, and I'm sure that was those were components of many things that we discussed last year. And it was such a common theme for a long time. And so I feel like the one nice thing about the car legal hotline, which I'll just give it a quick plug for our realtor members, that it's available from 9 to 12 and 1 to 4 Monday through Friday. And I like to say, with the exception of when I'm answering, you can always call and get a competent real estate attorney to answer a question or two for you if you have them about your deals. And that is free for our members. The calls on the hotline, when we get in an average 3-hour shift, we run probably somewhere between 17 and 19 calls in a 3-hour shift. So that's, 35 to 40 calls on average a day from 30,000 plus realtors all over the state of Colorado. And it gives me the ability, when I have the time to answer it, to really kind of track the stuff that everybody's dealing with. And so one of the biggest things I've noticed is the change in the tone and tenor of calls and the concerns that people have and the things that they're calling about. And where, a year ago, we were talking about dealing with multiple offers and kind of wacky escalation and appraisal gap clauses and other things. The things that I'm getting questions about now, I think reflect the market condition change that really happened almost overnight. February, or well, call it March, April of this year, is when I think we all started to see a dramatic, almost overnight shift. And I will not forget, the most reflective of that was when I was sitting in my office at Carr answering the hotline, and I got my first question about Foreclosure Protection Act contracts in, I would say, 3 to 4 years. Literally had not had a Foreclosure Protection Act question in 3 to 4 years. And I would say, I literally remember the moment when I picked up the call and they started asking me about it. It was one of these situations where they're like, oh, my prospective sellers in pre-foreclosure or some reference to something like that. And when do we need to use the contract? And it took me a second. I had to kind of, jog my head and recall and actually pull the contract up to look at the section for the applicability of that contract. But to me, it was a bellwether for a change in the marketplace. And I will honestly say that since that call, I probably am clipping along at, I don't know, at least 1, if not 2 or 3 calls a week having to do with similar sorts of questions related to foreclosure. So that to me is an enormous sort of indication of the kinds of things that people are talking about. And remember, foreclosure, I think, is a trailing indicator of kind of where people are, because, and I think what's happening, the reason I'm seeing a real spike in that is because you're seeing sellers who are behind, in some cases behind significantly in their mortgage payments. Maybe they took too much advantage of some of the foreclosure forbearance and some of the COVID, time stuff. And now they're seeing the market dip a little bit and some of their, appreciation that they've seen go. And so they're trying to jump in at what they may view as the tail end of a really charging kind of seller's market and take advantage of that. And when they pick up the phone, call their realtor, they say, hey, I'm under some financial stress and I've gotten some letters from my bank and I've missed some mortgage payments. And that's what invokes those calls. And I think that's the indication that I'm seeing on the foreclosure side of things.
And before you move on from foreclosure, Scott, one thing it is the Colorado Foreclosure Protection Act is now still in full force, guys. So if you have a buyer that's not going to live in the property as a principal residence, the Real Estate Commission has what would you call that? A flow chart as to how to determine when you need to use the Colorado Foreclosure Protection Act form. So make sure that you're reviewing that. As a reminder, the Colorado Foreclosure Protection Act is a risk to the buyer, not the seller. Seller and seller's broker do not have an obligation to tell that that the seller's in foreclosure or any of that. It's up to the buyer to do their due diligence to make sure there isn't something filed against the property if they're not going to live in the property as a principal residence. And make sure you're looking at that flow chart, because I could see where that gets a little messy for brokers and could be either discipline or a civil action at some point as we start seeing more of these.
Yeah, for sure. Another area that I hadn't had calls in for years has been some calls from listing brokers to say, what do I do when I need to make a price reduction, or when we want to do a price reduction? Do I do an agreement or an amend extend to the broker agreement? Of course, that's what you do and get that all memorialized. But when I started getting those calls, I'm like, goodness, price reductions, like, really? That's wild. Who does those these days? It's starting to happen. That, and the other thing I'm noticing, I live in Denver, and as I drive around on the weekends, I'm seeing open house signs, which, for the last 18 months, 24 months at a minimum, we haven't really seen those. Let's see. Another area that I'm getting questions on that I think is reflective of the marketplace is brokers calling about what happens when they're moving from brokerage firm to brokerage firm. I think maybe they've seen some stagnation in their business, or it's a good time. They don't have multiple deals that are kind of in the hopper, and they're seeing maybe they shake things up a little bit, in their brokerage office, or with regard to where their brokerage license is held, and so a lot more questions on kind of the what needs to occur when somebody is moving from brokerage firm A to brokerage firm B, and I think that's another indication of just some unrest among brokers in the marketplace. Earnest money disputes. I'm getting a lot more earnest money disputes year after year after year for various reasons are always one of the top phone calls that we get on the hotline, and we have just for years. But the reasons behind them change frequently. The one that, again, for me is reflective of the market condition change is more situations where buyer's agents are calling and saying, hey, we terminated the contract. We did it within our contingency. Everything was perfectly, legitimate. We had every right to terminate. We did it appropriately and timely. And yet the seller is refusing to sign the earnest money release. And it's just kind of seller being a jerk in some cases, or angry because, in the point between contract and termination, they've seen some market decline or market depression, or they're concerned about re-entering the market with their listing. They're a little more bitter and they're pushing back a little harder. And I like to point out to people that this new contract we have in paragraphs 4.3.2.1 and 4.3.2.2, there's now some teeth in the earnest money release, or a party, whether it's a buyer or a seller's sort of, we'll say, bad faith failure to sign an earnest money release. There's a little more teeth in that wasn't there before. I know Damian had some input on the clause. If you've got anything to say about that, hop in.
Yeah, I mean, the biggest advantage to that clause is just for you guys as brokers, when you have that dispute, use it with your seller to understand that if you're holding up the earnest money for no reason, help them understand that there could be some repercussions for that. Same with buyers. I mean, it now goes both ways, which I think is the biggest change we made. And let buyers know that if you're just demanding your earnest money, you don't have a right to it, that carries risk with it as well. So, that to me is a great tool for brokers when you have those earnest money disputes.
Yeah. Another area of hotline calls that I've been getting repeats on, and this one's kind of to me, it's a little bit of a heartbreaker, and that's in new construction situations where you have a buyer that went under contract, in some cases 12 or even 18 months ago on new construction. The deal was supposed to be delivered, maybe first quarter or end of last year, and it got pushed because of construction delays and builder delays and supply chain issues and everything else into the second and third quarter of this year. And the interest rates that they performed their original purchase at or went under contract at, they were looking at 2.5%, 3%, maybe 3.12% kind of interest rates. And that profile has changed pretty dramatically. And that has had an impact, particularly on some of those more entry-level new home buyers where, they can't just all of a sudden, do a 5.5%, 6% interest rate. And the impact on their monthly debt service is extreme. And so they're wondering about how can they get out of the contract. And, my unfortunate answer in most of those cases when I get calls is just, I can't really tell you because you're probably using a builder contract that, isn't a commission approved form. And I don't know what rights you have, but unfortunately, I think in many cases, particularly with some of the larger spec builders, a buyer doesn't have a whole lot of rights to terminate. And a builder often has pretty good rights to delay delivery of the ultimate construction. And so those two things don't often intersect well for buyers in that situation. All right, last thing I'll mention here, and this is always maybe a can of worms. In other markets, it's more than I think in the Denver market, but a lot more complaints and queries and questions about kind of what I describe as traveling realtors. And I think that is reflective of the market as well. Brokers are stretching a little further outside of their marketplace, willing to take a buyer up to the mountains. If they got a friend, neighbor, client in Denver who wants to buy something in Steamboat or buy something in Winter Park or Vail or pick your market. Whereas, over the last few years, as you've been busy in many of your own transactions locally, and market's been great locally, you've said, I'll just refer that deal. Now you're going, well, I got a little extra time on my hand. I'm going to go do deals in those marketplaces. And so the questions often come down to a matter of competency. I get listing brokers from those markets that'll call and say, well, don't they have to be competent? Don't they have to be geographically competent? And my answer is always, absolutely, they do. But, and that's an important point, and I'll come back to that in just a second. But I remind a listing broker, you've got a fiduciary duty to your seller. And in most cases, your seller doesn't really care where the buyer's broker is coming from. They want to sell their house. And so if you're in the situation on the listing broker side where you're being inconvenienced by an out-of-market broker who's coming into your market to bring a buyer, I always remind listing brokers to focus first on their fiduciary or their broker's relationship with their seller, and then to the extent that there's issues with competency after the transaction closes, then you can pursue those inquiries at that point. But similarly, on the buyer broker side, there's a lot of stuff that can go wrong, and there's a lot of nuances and quirks to the different regional, municipal, county by county real estate things that should be concerns, whether it's stuff with, oil and gas concerns, water concerns, short-term rental concerns in a lot of our resort markets where short-term rentals aren't possible. Metro districts and certain communities that have metro districts that have enormous, in some cases, tax or assessment overlays. A lot of things you need to be confident about in different marketplaces. And so be cautious as you are traveling with buyers. If you're going outside your market, make sure that you're comfortable and able to participate from a competency standpoint. So anyhow, those are some of the things that I've seen over the last few months that are inquiries that I just haven't seen previously, or I haven't seen in the last few years anyhow previously.
Yeah, Scott, along those lines of foreclosure, Keith Alba posted in the chat that apparently there's, according to Black Knight, there's 600,000 borrowers in the US that are 90 days delinquent that are not yet in foreclosure. So we might see more of that stuff.
Yeah,
this is a kind of a funny story. I got to tell you that, you say the market's changing and you talked about the price reductions and people asking how you do a price reduction for a listing or something. I actually got a call from a leader. She runs a team and she runs a very good team. And she said, I was having a conversation with one of my younger brokers and we were talking about, the fact that they were going to take this buyer out and they were going to make an offer and everything else. And she asked and said, so what are you going to offer on the property? And he says, what do you mean? He says, well, what are you going to negotiate as far as, are you going to go below list? He says, you can do that because, the market that they grew up in was, 2 years of it was either at or above list price. So, some of the brokers you guys are going to have to, dust off all the stuff on inspection and how you deal with resolutions and dealing with lenders and all that stuff is going to come back out. And it's just interesting. It really is a different market. And for those that got into it 2-3 years ago, it's going to be something they haven't seen period.
Yeah, no, that's absolutely true. A lot of, just no need to resolve inspection issues because the seller just says no, or the buyer in many cases has waived their inspection contingencies and everything else. So that's true. I can see that a very young broker might have some learning curve ahead with regard to how a normal market with a little bit of buyer and seller parity actually is versus just such a pure really historically crazy seller's market that is I think on its way out the door.
Yeah, and along those lines, I wanted to just mention a couple of classes that I'm now getting requests for. It's short sales, foreclosures, bankruptcy, and the one that I think is interesting is assumable loans. And I hadn't really, you and I just kind of talked about this briefly, but and I'm going to have to go do some research, but historic low interest rates on FHA and VA that I think are assumable, you could start seeing people trying to do some kind of assumptions with those because of the difference in the interest rates.
Yeah, it would be a pretty narrow bucket of loan types that would be that assumption would be available to. I mean, anything conventional, I'd just be stunned if there was an ability of a seller to essentially push off that loan to a prospective buyer or for a buyer to assume it. One of the things that popped up in the chat as well, and I'm glad you asked yet about sharing the hotline phone number. I'm only not going to do it because in order for you guys to get it, it's very easy to get. And if you're a realtor, you can just go to CAR's website and there's a tab on the top that says legal help. But in order to use the hotline, you've got to accept the terms and conditions of use, which essentially is, I'm an attorney or the hotline are lawyers, but we're not your lawyers. We don't have any attorney-client relationship. We can't provide legal advice. We can provide legal information. But if you go in there, put in your NERDS number and accept the terms and conditions, this very next screen will give you the number, and it is great to keep saved in your phone. And to the extent that you have questions about the transactions you're working on and everything else, I think it's an outstanding resource. So I don't want to just give the number here because if you call and you haven't accepted the terms and conditions, then you won't get your question answered anyhow. So
I think there was do you want to do some questions or you want to go into the rest of the stuff that we have? We could answer a couple of these questions real quick. Jill, you want to go through them?
Sure. Karen had said, I would like if radon testing companies needed to be licensed. has any impact on us as agents?
Okay, so this is about the new rate on licensing requirements, and I think it does have an impact on brokers. I'm curious to see what Scott thinks about this, but you know, for those of you that don't know, anybody that is doing radon testing now has to have a radon testing license through, I think it's DPOS, right? Or not DPOS, it's anyways, through like electric, what is that?
I don't actually know.
I can't remember what group it's through, but anyways, you have to be licensed in order to do radon testing. The one thing that I would say for brokers that you need to know is just be aware that there is that licensing requirement. So if you have an inspector that is going to do radon testing, or you have a buyer that wants radon testing, just make sure they know that they ought to check and make sure that their inspector actually has the license in order to do it. That's really the biggest thing that impacts you guys, is just being aware that there is this requirement now, and that the buyer should be asking and telling the buyer to ask the inspector to make sure that they know about it. So anything to
Yeah,
add?
so it's through DPOS, and it's the Office of Radon Professionals. And if you just Google it, you can and you can Google it and you can search for a licensee. So to the extent that you've got an inspector or some radon professional, if you, obviously this is primarily if you're working with a buyer's broker, unless you're doing sort of preliminary testing on a listing or something, you know, I would probably take the extra minute or two, particularly in this transition phase. I mean, it's fully implemented now, but it's so new. I can see where a lot of people are still probably out holding themselves out as being able to perform tests when they're not. Yeah, sure. I think a broker, I mean, I'll put it this way, it could be considered a negligent referral if you're referring somebody as a radon professional who's not licensed, and then they are performing testing. So that might be another thing to do, is have a look at your referral lists and update those, or just double check that whoever you've got on those referral lists and you're holding out as experts or you know, high level professionals, that they actually have gone to the trouble to get their license.
Karen just asked as a follow-up to that, if the clients choose to use a radon person who's not licensed, then is the broker off the hook?
I mean, the broker's never off the hook. You know, you've got E&O insurance, so you're always going to be. I mean, it would depend on the facts and circumstances. I mean, so let's say that you're a broker representing a buyer, and you haven't referred this professional to your buyer, and you really have no connection whatsoever. Your buyer just goes out and unilaterally goes and engages this radon professional who's not licensed. I don't necessarily think that you do. I think maybe it'd be a situation where you maybe shoot an email to your buyer client and say, hey, here's a link to this website, maybe double check and make sure they're licensed. I know they do have to be licensed, but I think that the liability would really primarily come if you're from a negligent referral standpoint. So you're making a referral to somebody who's not licensed, and they were performing that function. So
I agree.
And then Patrick said, for radon issues, is there a difference on testing and mitigation as far as the licensing requirement?
I
think it's just for testing, isn't it?
I don't know. I know it's for testing. I don't know about the mitigation. I wonder, would somebody who's doing radon mitigation need to be licensed through CDPHE or something?
I don't know. I don't know. I thought the only licensing was for testing, but I really don't know. I mean, I have somebody doing a radon class at some point, so maybe he can answer that for you guys if you want to take the class, because I just don't know.
You guys are dragging us into radon weeds here.
Alba said one for testing and one for installation.
There you go.
All right. Okay, going back to some Q&A. So Michelle says some listing agents are playing games, countering to an offer and then finding out they're still taking offers, and then push up the price if my client wants to increase the price.
Yeah, well, I mean, that's a residual issue with, I mean, that's just negotiations, and I don't know what to tell you. I mean, your client's got to decide what they want to offer for the property, and if they want to take chances on not, you know, getting the property, if they offer lower, then do it. If they want to get the property and want to take it off the market, then, you know, sellers might require them to pay a higher price, but that's just nature of negotiations, I think. I mean, I think we're going to see less and less of that as time goes on, but Scott?
Yeah, I mean, I would agree. We have obviously the code of ethics that is, has implications potentially. Article 1 speaks to treating all parties honestly and things of that nature. I mean, the tension in some of this stuff comes down to this tension between your fiduciary obligation to your client who's asking or requesting you to do something and your expectations under code of ethics and in some cases under license law. And I don't know that there's a great way to resolve that always. I generally would tell anybody who would call on the hotline or I speak to, always default to your fiduciary over really just about anything else, unless somebody's asking you to do something, that's criminal or otherwise. But to Damian's point, it's part of the give and take of a real estate transaction, and as long as you're informing your buyer or making sure that their eyes are wide open, and if they're willing to make some of those decisions and negotiate in that manner, I think that's on them.
Here's a question from Coral. So concerning HOAs, the HOA requiring construction completion regardless of supply chain issues within the 1 year as stipulated in the bylaws. Also, architectural review being very nitpicky. How do we advise our buyers to navigate?
I think this is an easy one. This is go find an attorney to help you with these things. These are, you're talking about getting into the nuts and bolts of bylaws and dealing with architectural control committees as far as what they can and can't do. You're going to have to do some review as far as, not only Kiowa, which is the Common Interest Ownership Act, but also with regards to the declaration as well as the governing documents of the HOA. So that's really a legal question for an attorney that represents your client.
I mean, I couldn't agree more. I think, it's funny, this conversation kind of came up I think maybe the last time we did a presentation together, Damian, by the group. And I really encourage brokers or our realtor members, when I have an opportunity to speak with them, to get comfortable with having a conversation with all your clients with regard to, what's a licensed brokerage activity and what you can't do, which in many cases is practicing law. Every single time I answer the hotline, I'll get some call from a buyer broker who's calling the hotline and asking questions about, oh, my client bought the house, they closed, they moved in, and then they found out this. And they want me to analyze a potential claim for them so they can turn around and analyze a potential claim for their client. And I'm happy to provide some sort of high level input and process kind of answers, like you got to request mediation, and depending on the amount of the dispute, it could be in what level of court, and if it's a big enough dispute, make sure they're getting with an attorney before they even mediate, and things like this. But at the end of the day, I have to remind them what comes out of my mouth based on what I described earlier to you is specifically not legal advice. But when it comes out of your mouth and goes to your client, it's legal advice. It's the practice of law. And so what you guys do is so immediately tangential to the practice of law. It is the practice of law on a limited basis, that you're constantly being drugged into these kind of gray areas where your clients are expecting you to do that. And you guys are people, right? In other words, you want to please your client. You want that buyer who closed, who's now ticked that something wasn't disclosed to them. You want them to refer you to other people. They want you to engage you to sell their house and buy their next one and everything else. And so you're in this really odd tension every time these kinds of issues come up. So as a broker, and particularly I say young brokers, really, everybody's going to have this conversation a little bit differently with their client, but setting the boundaries and in a good articulate way that's not off-putting, helping your clients understand what you can do and what you can't do. And when a real estate transaction is over, or when an issue within a real estate transaction is not a real estate transaction issue, it's a legal issue, being able to explain that to them in a way that doesn't put them off is an incredible skill set if you establish it, if you refine that conversation, you work on it. So I think it's a good example of why that's so important.
Yeah, and along those lines, I like to say that, you guys are the hub in a wheel. You're in the middle here, and your job isn't to do everything on the wheel. Your job is to be the hub that goes out as a spoke, and this person can get you information about HOAs, and this person can help you with title, and this person can help you with lending, and this person can do inspections, and this person can do appraisals. Your job is to help them find where to get the information, not to be the source of the information. Because once you become the source, or you're the one giving the advice, whether it's oh, you can do this with the HOA, or, oh, I talked to the building department. They say you can build another garage on the property, or you're just opening yourself up to that liability. Your job is to help them find the information for them to go get it themselves and make their own decision, not to run it all down and make these guarantees or warranties that all of a sudden it works for what they thought they were getting. And that's where I see a lot of brokers get in trouble, is just overstepping that, trying to help so much, as Scott says, being a people person and trying to help your clients to the best of your ability, and just going too far with it.
But before we move on, I want to point to a comment that seems to have gotten skipped over. It looks like Deb Kirschbaum, Damian, would like to see a rewording of 15.3.3 in the contract to buy and sell.
Oh, that's really too bad that got skipped over. Thanks for bringing it back up, Scott. I really appreciate that. Number one, I will tell you that when the contract gets redone, I guarantee there will be rewording on 15.3.3. That being said, it will not happen this year. So you guys got 3 years for that. That's the moratorium that the commissioners put on all forms. So we'll be working on that, not next year, but the year after. Really read that language, guys, because I don't think it's as bad as you think it is. It really talks about if it's referenced in the status letter, that who it has to be paid by. And if you look at it, it's based on, there's two different categories. One is normally a buyer cost and the other one is normally a seller cost. And you just, look at that section again, but I don't think it's as bad as everybody seems to think it is. But obviously, there's been enough people that have complained about it. Thanks, Scott, for pointing that out, that it will end up on the list once we get back to the contract to buy and sell.
I think generally in talking about that though, in most cases, absent specific negotiation otherwise, in 15.3.3, that ought to be paid by buyer. So you ought to be checking buyer, not seller.
Yeah, it's got assessments and working capital and reserves. I mean, check the box buyer. And what's happened is a lot of the sellers aren't looking at what box is checked, and then they're getting hung with the assessments because something in the status letter said that, oh, and we need 3 months, we need the next 2 months of assessments or something. So pay attention to the contract.
Well, worse yet is when listing brokers get hung with them because because they didn't point it out to their sellers, and their sellers are ticked, and now they're giving up part of their commission. I've had a variety of spins on that call over the last, since January 1st.
Yeah, like I said, we'll work on it, but pay attention to the contract, guys. I will tell you, if it does get reworded, it's just going to be reworded. So it's still going to be this liability outstanding for you. So if you're a listing broker, make sure you're checking that paragraph and you know what it says and you understand what the implications are. We have anything else? I have some long. This might be a little long for us to go through.
What's that?
Oh, there's a question, but it's like 4 long. Well, I'll let Jill decide what she wants to do with that. You want to move on?
Maybe we tackle that one offline, Noel, if that's okay. I think that's just a lot to go through specifically.
Yeah, I see somebody, Ben raised the 15.3.3 again. Like I said, Ben, you check the box buyer and it doesn't cost your sellers anything. I mean, that's really the trick to 15.3.3 is making sure that you're checking the right box. So, all right, what do you want to talk about?
Well, what else we talked about yesterday? We talked about, or when we were prepping for this, what else is on your notes?
I think you got to talk about the vacant land fraud, since we're obviously, you and I did that presentation at Summit, and we both got calls over it. So I think it's definitely worth repeating to everybody here, even the people that may have heard it before, to know that this is still alive and kicking.
Well, alive and kicking and re-kicking, I guess. I would say for the vast majority of summer, this percolated up in spring, and I'll come back to what this is in just a second for those who aren't familiar with it, but it percolated up in spring, and this was another one of those calls that I literally remember them, the moment as I received it, I'm like, this is wild. And it went on for about a month, and I started to get a number of calls, and then it kind of died out for a good part of the summer. Over the last 3 weeks, I've probably had 4 or 5 other calls about the exact same issue. So the issue is that what we've just been referring to as the vacant land scam. And the scam it makes like the whole concept of wire fraud that we used to have to worry about seem like a really, really complicated scam, because this one's pretty easy. And what I think the general profile of it is this: out-of-state seller, quote unquote seller, of a vacant piece of property ideally that vacant piece of property does not have any debt or encumbrances on it. There doesn't have to be any loan payoffs or any other, title clearances. It's a clean title to a vacant piece of property. Often we've seen them in more remote areas, and these will be like a vacant lot, and the first call I got came out of Crested Butte, Colorado. It was a vacant lot, and this was one of two that I'm aware of that actually closed. And it was the first one I became aware of. It was the first call I got, and the broker called and said, "Hey, I have a broker in my office. She closed on a property 2 weeks ago. The day after closing, she got a call from a neighbor, an alleged neighbor of the property she closed on, and that neighbor asked her to list their property." So the profile of the closing was this. It was the first closing. The broker was representing a buyer. The buyer identified through some syndication site a for sale by owner vacant piece of land, which is what they were looking for. It wasn't listed on the MLS. It wasn't listed by a broker. It was FSBO. And so the buyer says, "Hey, I'd like to see this." Agent reaches out to this out-of-state seller who's doing the FSBO and basically says, "Sure, I'm happy to work with a broker, happy to pay a commission. Great, get me an offer." And so she prepares an offer for the buyers, goes through the transaction. It's a quick close. In that case, there wasn't even a loan. They closed, it was about a $500,000 transaction, and they closed in a very short period of time for cash. And then the next day she gets a call from a neighbor of the alleged seller who says, I heard you did a great job. I'm looking to sell my lot. I'd like you to list it." So she actually lists it, puts it in the MLS, puts a sign in the front yard or on the lot, and gets a contract on it. It goes under contract. Before closing, she gets a call from the actual property owner who says, "What the hell are you doing selling? What's your sign doing in my yard? What's going on here?" And so she panics and puts together the fact that this was essentially the same set of scammers who have been perpetuating this. And this is throughout the state of Colorado now. So remember, the property in Crested Butte closed. The second one was under contract. Obviously, they terminated that contract. And in the meantime, she had another inquiry from another quote unquote seller to list their property, which obviously she declined to do. And so anyhow, that's the basic scam. And Damian was one of the first people I called after I got off the phone, because I was like, there's got to be some way this gets tripped up. And the way it gets tripped up, I think ultimately, if there's got to be a loan payoff and the lender is going to be working with their borrower to pay something off. It works with vacant land, but it wouldn't work with a property that needs to be accessed or inspections done, or a lot of kind of work done like that, and from a due diligence standpoint. But a simple piece of kind of residential vacant land in a remote area, the scam kind of works. Sellers never met, or sellers never showed up at closing. They did everything remotely. They closed, they did mail out closings. We don't know whether they're using either a notary who's in on the scam, or if they're just buying, a fake notary stamp from, China or whatever, and using that to close. I think it's very easy to get fake IDs for anybody that really wants them, again, from overseas, and very cheap and easy to get your hands on. So they do a little bit of research on the public or the property records. They find ideally like a single owner, vacant piece of land, no debt. All of this is public information. Reproduce IDs and start calling brokers to see if they want to list it, or in most cases, they do the listing themselves and allow buyers to find them. This tapers off a little bit in the less hot market, right? This was late winter, early spring this year, and so the velocity made a lot of sense. But anyhow, that's the scam. It went away for most of the summer, and I've had I think three or four calls over the last 2 weeks from different brokers who say, "We saw your video, we saw some of the messaging that Carr did with LTAC, and I just want to let you know, hey, I just got this call, and I knew it was a scam. Checked into it, and sure enough, when I did the research on the seller, it was a scam."
Yeah, I came across that too after you and I did our presentation in Summit. So I'll tell you what some of the title companies are trying to do with this is they want to send out letters to the public records that they have on file for the owners. The one that I had came out of Summit was it was somebody from England that was selling a lot, and the person that the broker got a call from was from England, and then they got another call from somebody else from England saying, why are you selling my lot? So, I mean, it's very, in some respects, it's simple, but in other respects, it's somewhat sophisticated, because they figured out to perpetrate the fraud from wherever it is that the seller is purportedly from. You know, we have one that was in New York, another one that's in England, you know, so they figured out a way to do that. But yeah, I think a lot of the title companies are really trying to hone in on, you know, sending letters to get some kind of response to make sure that they can somehow verify the identity. And I know that there's a lot of title companies that are dealing with this right now. It's a bigger problem than what, you know, you and I even thought when we started hearing about it. We thought it would kind of be a flash in the pan, but it keeps rearing its ugly head.
I
Yeah.
can't speak for all the other companies, but I know what Heritage is doing now. Anytime there's an absentee owner, 100% of the time we mail them a letter that says, just so you know, we've been engaged to facilitate a closing on your property. So just to try to protect against these kinds of circumstances.
Yeah, and the scam, I mean, what's scary about it is this, is so Scott talked about the one in Crested Butte that got on loan. Luckily, the buyers hadn't done soils tests, hadn't started architecture, digging out a foundation, doing any of the stuff that, what if they had built a house before the old seller says, oh, by the way, that's mine. And keep in mind, as far as I saw somebody had a question about title lock and everything, the title doesn't transfer to a fraudster. So unfortunately, it would be the buyer that would be out here, and then their title commitment only cover the purchase price of the lot. So if they bought a lot for $300,000 and put $1 million into a property, they're out the $1 million. And it doesn't, the seller, doesn't, it doesn't go away for them. Scott, you talk about Google Alerts, and would you mention that again? Because I think that's a great thing for brokers to know about.
Yeah, well, I've talked a lot about Google Alerts for years for different reasons. But for those of you who aren't familiar, it's totally free. You can go to, and I'm sure there's other services that do it other than Google, but you can go and set up a Google Alert. And so you put in your address as an example, and then it's kind of like a reverse search almost. So anytime some website initiates a new touch point on whatever your search term is, you get an email that says, hey, this came up today. And so I think realtors ought to do it with their name, with their brokerage company, tie something together. You don't want customers that are putting bad reviews out there about you. If they are, then you want to know about it. I think I've talked to brokers about using it with their own. When you take a listing, put your listing address into Google search and set up a search alert so that if it comes up and somebody else is using it in a way that you're not authorizing or you don't want them to be using it, then you want to know about that as a listing broker. And we had a lot of the scams through like Craigslist and other places years ago, where they take an active listing, take a couple of photos from it, and then try and set up a for lease kind of situation on the side and see if they could induce people to send them security deposits or down payments or whatever. For all of those reasons, it makes a ton of sense to have. But I think a Google Alert would have addressed for the actual property owner in like the Crested Butte example, if it was listed on a syndication website as a FSBO address, I think that would have pinged them to say, hey, your address that you put in is now being listed for sale by owner. And I think that's a free, easy way to kind of monitor what's going on. But if you stop and think about all the ways, particularly as a licensed real estate professional, as a person whose reputation is everything in this world, I mean, every one of you guys that's a realtor, your reputation's everything. You want to know how your name is being used and what people are saying, past clients, whatever it might be. So it's a great tool to use for a lot of things.
And Chris Hardy put it into the chat for those of you wondering how you access it. So thanks, Chris.
Ever the resource, Chris Hardy, aren't you?
Yeah, between him and Scott Salmons and a couple others and Keith Alba, and they keep throwing up resources for us in the chat. So
I know they're perfect.
Good thing we're not prepared, but at least somebody else is.
Yeah, Scott. I see Scott put the flow chart in there.
Yeah.
And,
I think somebody else sent the brochure on the radon licensing. And,
yeah, Keith's got the radon. I don't know why don't we just check off and let these guys send?
Yeah, we go. These guys teach the class. I think so. If you're ready to move on, somebody already asked if we've heard anything about the listings for 40 years where these companies are coming in and
I'll let you just, I'll let you describe that. Joe, you got a fly there. I see you
I've
swatting.
got a fly. Can you see me flailing? I've got my swatter.
It's your thing.
I'm gonna get him.
it looks like a tennis racket.
I'll see if I can get him through my my butt be gone through the screen.
We'll tag team him.
I live in the city, so I don't have to deal with too many flies, fortunately.
Well, I'm going to talk about, I'm going to use the name just because it's out there and I think you've heard about it. It's called MV Realty. And they came up with, guys, I'll tell you, they came up with honestly, they came up with a program that is unique and it was innovative. The problem is that I think it probably has a lot of problems legally. So other than that, it was great. But the story is that seller says they advertise out to sellers. They're in 33 states, by the way, just so everybody knows this is not a small outfit. But what they do is they say, hey, seller, how would you like to make some money? Seller says, I love money. Who doesn't? And so they say, okay, what we're going to do is we're going to give you $2,100 and we'll give you this $2,100. We're going to sign an agreement. And in the agreement, you're going to agree to a couple things. Number one, if you decide to sell your house in the next 40 years, you go ahead and you agree to use us. They talk about commission in there. We're not going to talk about commission because obviously Scott will blow a gasket and we don't want to talk about commission with antitrust and all that other stuff anyways, but you'll pay us a commission. So in 40 years, you sell the property, you'll pay us a commission. It's outlined in there. The other thing they did with this is that they did a memorandum of agreement. And what that memorandum of agreement says is, hey, we got this agreement over here. We just want to make sure we record it against the property and make sure that, that the seller doesn't change their mind and go to sell somebody else. And it runs with the land. So it's an encumbrance and a lien against the land as this agreement. Now, there's a couple of legal problems with the agreement in the fact that I don't know how, it's enforceable, but I think there's problems with it that if a lawyer could challenge it and probably get it overturned, but think about the legal costs of being involved in that if you went down that way. But more importantly, you had brokers that were creating these things, and we had a couple different complaints to the real estate commission on it. One of them went like this. Seller did it 9 months later, forgot that they had an agreement, went ahead and listed with somebody else. During the course of the transaction, the entity went ahead and filed a lis pendens and a lawsuit against the buyer while the contract was pending, and then tried to collect from the title company. Title company, I don't know what they said or didn't say because I haven't seen any responses or anything else, but my guess is title company said, well, it was an exception in our title commitment, so we're not going to cover it because we took exception to it. That's my guess. So the buyer now has a lawsuit they inherited from a lien for an agreement that they got literally nothing out of. So you can see where this made its way to the real estate commission fairly quickly. I will tell you what's come out of this. So for those of you that are thinking, oh my gosh, this is genius, I think I got to fly too. That are thinking this is genius, I want to do it. Real estate commission heard this at the last meeting. I'm assuming it's the same company, even though they don't identify them, just because the facts line up too similar. But essentially they said, okay, well, we think this is a violation. We're going to hit you for deceptive trade practice, or not deceptive trade practice, what was it? Deceit or something like that. Not good. And you get $15,000 fine per thing, which is, there was two of these. So $15,000 per complaint, public censor, revocation, and they referred it over to the Attorney General's Consumer Protection Department. So I have a feeling, now I'll tell you guys, we have not heard the last of this, because from what the report said, assuming this is the same company, because I really don't know, there were 614 of these agreements in Colorado. Now, if all of them were $1,000 to $2,000 that they paid these sellers, you can see where the cash outlay that they had for this program was immense. So my guess is that this thing's going to make its way through the administrative law judge and possibly end up in court as far as an appeal, if at some point, just because of the amount of money that's at stake. But currently, Scott and I have heard a lot about this across the country too. Scott put me on a thing called Vacant for, for car and all attorneys that represent associations. And we've seen a lot of different attorneys talking about this thing. I'll tell you, the regulators have told me that a lot of the states are talking about it too, trying to figure out what to do with it. So that's what's going on with it. I think it's going to end badly for them, but who knows? I mean, maybe they get a court decision that says that this is okay. But Scott, you have anything to add?
No, I mean, not to this particular story, but I think it's a great illustration of how important it is to be paying attention to title commitments, to, title, the exceptions specifically, and the things that are recorded. And I think, unfortunately, too often buyers don't pay enough attention to title policies or title commitments, I should say, and CIC documents. Those are the two areas. It's so easy for a buyer to get that stuff, and they're voluminous, they're confusing, they gloss over them. And both of those two things are loaded with potential issues, problems, concerns. So anyhow, this story is another reason that I think it makes so much sense to pay attention to those, particularly those two buckets of documents.
Yeah, and what's scary about it is I had another one that did not file a complaint, but the broker, how brokers aren't supposed to review title, and you guys all do anyways, but you don't, which, to be honest, I get that you guys are involved in the transaction. You just got to remember that that's not your job. So if you're looking at that stuff, make sure that your buyer doesn't have an expectation that you're reviewing that stuff, because you're not supposed to be doing it. But we had one instance where the broker saw something, thought it was a little weird, called me and asked me about it. And I said, well, tell the buyer we want it removed because it's on there. And what what the company's response to it was, oh, well, we'll remove it, but we remove them if you ask us to. But if you don't ask us to, we won't, which is scary in and of itself, that the seller completed the terms of the agreement, and yet they were going to leave it as a cloud on title. So I think Scott's point of, regardless of whether it's this or anything else, buyers need to review title, guys, and you're not supposed to be doing it. So, make sure you have something that you're sending out to your buyers to advise them, to make sure that they are reviewing it. I think Jill has a script on this, and we may have talked about this before, but it is just so important to make sure that they're reviewing those things. Otherwise, they could get stuck. In this case, they were suing the buyer for $21,000. So, it's something to be aware of. And Chris says, but the memorandum wouldn't show up on an O&E, right? And it actually would, because it's showing up as an encumbrance. It should show up just like, a declaration or covenants or anything else. It's gonna, or recorded lease. I mean, it's the same thing. Once it's recorded, it should show up on title. So O&E is good. I like TBD commitments, but if your title company is at least making sure they're doing the search for name searches, then an O&E is really good.
I would say, though, if you have concerns, definitely a TBD, because a TBD is going to have, that's a full-blown exam of the property, whereas an O&E is often an automated product. So because that is kind of a unique document, you could see where that automated process cranking out a $5 O&E maybe wouldn't grab that. So I would say TBD if you're at all concerned that it could be out there.
Yeah, and you could have your seller pay for it, and then they get a credit at closing if they close. I believe that's the way the TBD product works because of insurance rules. Anyways, that one was fun. So we'll see what happens. I'm kind of looking forward to see what happens with that one, but I'm a geek.
Part of me wishes that they'd made me an offer. I think I would take it.
Well, yeah, I thought maybe we should have taken it a long time ago. It'd be a little hard now, but
yeah. It'll be interesting to see how that one resolves for sure.
Damian, somebody asked earlier, you said the buyer had a lis pendens filed against them. What does that mean? Do you mind just touching on that?
Yeah, so lis pendens is a court document that lawyers use when they're trying to essentially tie up properties. So in this case, there was this memorandum of agreement. And what the company was saying is, actually, they may not have filed a lis pendens, because a lis pendens is used when you're trying to sue for the property. So let's say a buyer has a contract with the seller decides not to sell, buyer sues for specific performance. The buyer would go ahead and file a lis pendens. They file the lawsuit and then get a lis pendens against the property. And it puts everybody on notice that you can't sell the property anymore because there's this litigation pending. In this case, I think they may have just filed the lawsuit because it was just over proceeds. So it probably wasn't a lis pendens. My apologies, I misspoke, but that's what a lis pendens is.
PJ had a question. She says, I've been seeing a lot of forms presented from both sides that are in violation of Rule 7.1, use of standard forms. I have been advising my clients not to sign. How do we stop this?
Well, I guess it depends on what forms you're seeing. You got to remember our world in 7.1 is actually fairly big. I mean, if it's a disclosure form, then it's not a violation of 7.1. If it's a bank form, it's not a violation of 7.1. If it's a form from a builder, it's not a violation because I'm sure that the builder instructed their broker to use it. So I
It's a form for a client is probably the biggest one. I mean,
yeah,
I guess, I mean, that's a builder in that situation, but yeah, to the extent that the parties are offering or are requiring the use of a specific contract document or whatever form it may be, if it's being initiated by them and you're retaining their request for you to proffer it via some email or something like that, then you're allowed to fill in the blanks on that form, and as long as you're not providing any advice on the form.
Yeah, so it really depends on, PJ, what form you're talking about as far as whether it's a violation or not. So
she just added, sorry, I mean addendums written by a party in the contract that is not an attorney.
Well, they're a party in the contract though. So that would be considered a client form as an example. It'd be the same thing as a builder form. Builder doesn't have to be an attorney to draft their own contracts or to offer their own contracts. And so most people don't, because we've got a really great form set, but to the extent that a buyer and a seller of a home wanted to use something other than the commission approved forms, you as a broker would be entitled to work on that transaction. You might want an email in your file to whoever your client was explaining, hey, this is unorthodox. It could affect the marketing and sale of the property, could affect the viability of your offer, and I can't advise you on whatever you're using, but beyond that, there's a pretty, Damian said it dead on. 7.1 is a pretty expansive list in a lot of ways. It's not strictly confined to commission approved forms.
yeah, I think the best thing is just make sure that you tell your client. I do see this come up a lot in like iBuyers kind of stuff or wholesalers or something, where you have somebody that's more sophisticated that's looking at buying it, that wants to change the terms of the contract. And if that's the case, the other side is providing that, then just make sure you warn your client, like Scott said, about, these are the risks associated with this. So you need to, weigh whether this is worth accepting or moving on. So that's, and maybe get an attorney to review that if it's not something that's commission approved form. Where are we, honey? I know we're coming up on the hour.
See, Patrick. Yep, we are. Patrick just asked, would examples be like relo and bank addendums?
Yeah, and those are allowed under 7.1. Those are bank forms that isn't that, I can't remember the exact language, but it's like title company forms and government entity or government forms. Or are you looking for your list?
I'm looking for my manual that I see right on your shelf behind you there, Damian.
Fine, I'll look at it.
All right, I have mine too. Handy dandy. This was 7.1 was expanded for, there was a lot of discussion about this particular issue just a few years ago, and it government lender forms, government/lender forms, I think is what that would be.
So government lender forms, and then you have one for title company forms, disclosure forms, Colorado Bar Association forms, client forms, attorney forms. I mean, there's a, when this was updated, what it was meant to do was just to add clarification. It was not meant to limit what you guys get. So that's why it's very expansive. And just so you know, Scott worked on that extensively when that legislation was passed to make sure that it wasn't tying your guys' hands on your transactions, making sure that you had a lot of flexibility in the types of forms that you could use.
One of the things that they threw out that I see now is affiliated business forms and mold disclosures. So yes, those are disclosure forms. As long as they don't create or waive any rights, then those are fine. I get this question a lot, and I know we've talked about this, Damian, you and I, and there's a bit of a conflict with this. But when a brokerage firm representing the seller, as an example, the listing brokerage firm, they have their own office policies, or they've got their own set of disclosure forms that need to be utilized in the transaction. When they're pushing those on the buyer broker or the buyer to execute, as a general rule, unless the contract or some other document requires that the buyer execute or acknowledge or, you know, do anything with those forms, buyer really doesn't have to. And so I think it leads to a lot of tension in transactions. And I get calls from this all the time, and it's not just listing brokers firms that do it, to buyer broker firms, it goes the other direction as well. I usually tell brokers, like, first of all, it's up to your client who's not the client of the firm proffering it. If they want to sign it, great. If they don't, the problem is you as their broker can't advise your own client on those forms because it's not your client's form and it's not a commission approved form. So you're kind of stuck in a little bit of a quandary in that regard. But it's up to them. And every transaction has, I believe that a practical good broker does a good job at picking their battles. Some hills are worth dying on and fighting for, and some aren't. And that's a perfect example of an area where I say, you know, you got to pick your battles. If you're in the pole position of the transaction, and you know, and you have the ability to exert your authority to have them sign this or not have them sign this, then I guess go for it. But you've got to balance that against, you know, what is this? Is it worth fighting over this when in fact we're going to have an inspection resolution coming around the corner that we may want to save our battle for? So I think that sort of pragmatism is super, super important. And again, at the end of the day, it's up to your client as to whether or not they want to sign something. But I know it's a source of great frustration. And anyhow, and there's a little bit of a confusing line or two in our license law that further confuses the issue. So
yeah, and if you're talking affiliate business arrangements, what I would do is, if you're the one giving the affiliate business arrangement disclosure and the other side refuses to sign it, just have an email that shows that you gave it to them, and then you can be pragmatic too. There's no sense in battling over that for you either. I mean, it works both ways. To me, you met the intent of the law if you can show that you at least provided it, whether it's signed or not. To what's going to happen? I mean, somebody's going to, oh, well, you didn't get it signed. You didn't go over to the buyer seller's house and pull a gun out and put it to their head and tell them they have. I mean, it's unrealistic. The law is really unrealistic. I mean, having your client sign is one thing, but having somebody else's client sign is another. And so, you know, just make sure you have something that shows that you did your due diligence. That's really the important part of this.
It's these damn lawyers, Damian, that screw it all up. You know, they keep coming up with all these disclosures and affiliated business and on and on and on and on and on. What did Shakespeare say? First thing we do?
Shoot all the lawyers?
Something like that. I don't know.
Drown all the lawyers? I don't remember.
We get to make lawyer jokes, Damian.
We got that going.
Nobody else does, though.
Yeah. You like lawyers. Sure, that's, yeah. Oh. All right. What do you think, honey? Are we done, or you want us to?
Yeah, I think we're about done. One quick thing I wanted to mention, going back to the very beginning of today. If any of you are not currently receiving a weekly foreclosure list and you're curious to see a list of all the properties that have entered the foreclosure process, reach out to your Heritage Title sales executive, shoot an email and just say, I'd like to start receiving your weekly foreclosure lists. We send that out every Friday. So happy to provide that as a resource if it's helpful. With that, we'll wrap up.
Do you know who my rep is?
Yeah, I'll find you a good sales rep.
Okay, thank you.
At the company. All right. Well, thank you so much, everyone, for joining us. It was great to have you today. Scott, Damian, as always, you guys are wonderful. Really appreciate your insight. Just thank you so much for your time. We know you're really busy. So thanks, everybody. And we'll look
Always
forward to
happy to
seeing
do
you.
it.
Thank you. All right. We'll look forward to seeing everybody next month. Have a good one. Have a great long weekend.
Bye, guys.